And just when you thought that you could have a court that was not, you could not have a court that was as terrible on guns as the Ninth Circuit Court of Appeals out there on the left coast of California and so on, you have the Fourth Circuit competing hard to try to earn the title of terrible anti-gun, anti-American, anti-constitutional court, disrespecting the Bill of Rights in all respects, especially when it comes to the most important right, the right to protect oneself against tyranny in all its forms. Nevertheless, let us carry on. Specifically, in the case of Stephen Robert Brown versus the ATF dealing with 18 to 20-year-olds, as you may recall, there was a major victory last month involving 18 to 20-year-olds in the state of West Virginia that had sued, claiming that their inability to be able to acquire handguns from a federal firearms licensee was unconstitutional under the Second Amendment, under the Bruin analysis, which of course the Bruin analysis is really the Heller analysis that's kind of gussied up and reaffirmed in the Bruin case. That's Nyserpa versus Bruin from 2022. And the judge there, Judge Thomas Klee, the district court judge in West Virginia, found in a compelling decision that indeed that federal law that prevents 18 to 20-year-olds, Americans, by the way, from being able to acquire handguns from FFLs violated the Second Amendment and the Bruin Standard in all respects, and therefore he enjoined, initially at least, he enjoined that law from being enforced against the plaintiffs, and he then, though, at the request of the ATF, says, well, they asked for a stay of the decision in many respects, saying, well, don't let this decision go into effect. We don't want to have to tell our ATF agents the hard work of that they have to respect the Second Amendment. So unfortunately, Judge Klee, in his decision, he said, okay, I'm going to agree that this violates the Second Amendment. I'm going to state that this should be enjoined, but I'm then going to agree with the ATF and I'm going to stay, which means to pause or freeze the effect of my judgment. So Judge Klee enters a victory for the Second Amendment, a judgment in favor of the Second Amendment, but then he basically stays it with respect to everyone except maybe the plaintiffs.